Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning and welcome to the meeting of the Court of Appeals. Today we have a panel made up of Western Section judges, even though this is a Middle Section case. I want to take just a few moments and introduce the panel before we get started. We have with us Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. And let's see, Mr. Julian, you're representing yourself today. Is that correct, sir?
Can't hear me.
I think you're muted.
Yes, sir, that's correct. I'm representing myself pro se.
Okay, all right. Let me make just a few announcements about what the procedure will be, and then we'll immediately get the case started. First of all, each side has 15 minutes to make its oral argument. Mr. Julian, since you are the appellant, you have the opportunity to reserve up to 5 minutes of rebuttal time. And if you do, you can choose to reserve rebuttal time or not, totally up to you. But after you introduce yourself, before you begin your argument, you need to let us know how much rebuttal time you need to reserve. Ms. Morgan, you don't get any rebuttal time since you're the appellee. Again, Mr. Julian, because you're pro se, I want you to understand what we're going to do today. We'll hear your argument, we'll hear Ms. Morgan's argument, and then we will take the case, review the record, and we'll write an opinion. Hopefully we'll get that opinion out as quickly as possible, but we won't make a decision today. Any questions before we get started?
No, sir, I don't think so. I've been watching some of these on YouTube.
Okay. Again, I want to thank Mr. Hibner. He has been the mastermind behind all this and is in this strange situation we find ourselves in the court system. He's made it possible for us to continue to hold oral arguments, and he and the AOC staff have done a wonderful job. And I think it's worked well, and we managed to keep the wheels of justice turning even in this pandemic. So, Mr. Hibner, if you'll call the case, we shall proceed then.
Marvin, Duane, Julian versus Debra and Julian.
Mr. Julian, you need to introduce yourself for the record, and then let me know if you want to reserve any rebuttal time, sir.
Good morning, may it please the court. I'm Duane Julian. I'm the appellant pro se in this case, and I'd like to reserve 5 minutes of my time for rebuttal.
All right,
This is a divorce action pursuant to a prenuptial agreement wherein it was agreed that my ex-wife would receive 1/2 my net worth at the time of the divorce, which was granted on January 14, 2019. The trial court never determined my net worth at the time of the divorce. Instead, it engaged in unfounded speculation about around $400,000 in unidentified assets without even stating where the property was or where it might be hidden, and after finding no proof of any hidden assets. It then split the unidentified property to award my ex-wife $200,000. The trial court also never addressed my liabilities, and it failed to address the indispensable requirement of the parties' prenuptial agreement, which was to assess my net worth at the time of divorce. Moreover, this decision violates the material evidence rule and should be afforded no deference because it's unsupported by any evidence and it's internally contradictory. First, to reach the decision, the court had to ignore substantial and essentially unrebutted evidence that I had about $69,000 in liabilities, which exceeded my assets of around $21,000 at the time the divorce was granted on January 14th, 2019. The affidavit of income and net worth submitted to the court showed my negative net worth at the time of the divorce was just over minus $47,500. But that was not the only evidence to this effect. My tax returns for the prior 15 years showed net operating losses and no reported W-2 income. My Social Security statement showed no earned income for at least a decade before 2019. My bank account had a balance of only $61. I live in a small 300 square foot garage apartment provided by my father, and I was, and I still am, receiving public assistance. This situation
What is the nature of
was,
your public assistance, Mr. Julian?
excuse me,
What is the nature of your public assistance?
SNAP benefits, otherwise known as food stamps, which I've received since October 2016.
Okay. Is that the extent of it?
So far it is, yes.
Go
Were
ahead.
you asked what happened to your assets? Was that the evidence at trial?
Yes, there are 45 volumes of evidence at trial, and I can explain the situation of how it came to be, these reversals that I suffered. Shall I proceed?
Yes, please, go ahead.
Okay, the situation was the result of several financial reversals I suffered in the past 20 years. One included a massive loss on 41,500 shares of Enron stock and a failed tree farm venture that I sold in an absolute public auction along with the bulk of all my other assets. Further, my ex-wife admitted under sworn oath, and the trial court explicitly found there was no evidence that I had any hidden assets. No one's ever pointed to any missing accounts or other assets. And it's because I don't have 400,000 that's missing, that's hidden, it's unaccounted for, or any way otherwise. Over 8 months before the trial, the court ordered each party will make a list of any outstanding discovery and file the list with the court. The court's order is found in Technical Record 5 on page 642. But my ex-wife never made and filed any list of outstanding discovery that the trial court ordered, which explains why the record is devoid of it. On the other hand, I did make and file my list 10 days later on August 31st, 2018. But my wife never provided me with the items that I made on that list. I even signed a blank release prepared by my ex-wife's attorney that allowed her to get any and all financial records she wanted. A copy of that release that I made from the certified record is attached as Exhibit A on my reply brief. Thus, all the affirmative evidence pointing to a negative net worth that I had with the court found no evidence of any hidden assets. Yet the court, based on a vague and an unexplained sense of the equities, split 400,000 without even specifying what property it was splitting, where it was, or where it might be hidden. That's all against a mountain of evidence that no such property exists. Further, my liabilities were never even considered at trial. The decision is without basis, and this court should not defer to it. My ex-wife has never offered any evidence, and the court never identified any evidence rebutting all the volumes of evidence that I have any assets that exceed my liabilities as of the time of the divorce. And neither the court nor my ex-wife ever identified any evidence of hidden assets. It's apparent the court simply plucked $400,000 out of thin air, and there's no basis whatsoever for it in the record.
Let me ask you, Mr. Julian, the court found after listening to the proof that you did not account for approximately $400,000. What is there in the record that we can look to that would account for this $400,000 that you say you no longer have?
It would be in the volumes of evidence that I provided, like 58 state and federal income tax returns, over 10 years of my bank statements, all the records of the absolute public auction and the net proceeds I got, which in 2012 amounted to $250,000, but after I paid my debts of $125,000, I only had $125,000 left in 2012.
Now,
So
now, during your separation from your wife, you made a number of transfers to relatives. What proof did you put in the record that these transfers were in fact appropriate and were not for the purpose of hiding assets from your wife?
Okay, the largest one was where I had an account with TD Ameritrade that was dormant for years. It was actually a 20-year-old account. And what happened is TD Ameritrade offered a promotion if you reactivate an account. I didn't have the funds to do that, so I refashioned that account into a joint account with my father, and he funded it with 3 separate capital contributions that I provided in discovery to the court and also to Ms. Morgan. No one ever questioned those forms, which was a check for $250,000 showing it coming from his separate property, another wire transfer from his separate account, and an old Charles Schwab account he had. So that went into a joint account that listed myself, my father, and then my father asked that I add my brother in case something happened to us. I traded that account for a year and it was marginally successful. It made about $20,000. At the end of the 1-year period, TD Ameritrade wouldn't grant us the same incentives. And my father was also beginning to suffer from some health issues. So we didn't extend that, and I returned to him his money plus interest of about 2.5%. And I returned a gift to him of $14,000, where he'd put $14,000 in my account the year before for Christmas. I didn't think it was appropriate because it made so little for me to take the earnings from that account. But I did report all that on my taxes. I did give them all the copies of the TD Ameritrade statements. And it's not the type of account where if I was trying to hide something, I'd put it in my name, file taxes on it, and provide everybody copies of it. It also wasn't challenged at trial, and I think the judge understood from the evidence that this was my father's money and that I simply returned it to him.
What proof did your wife put on about the $400,000?
There isn't any. She relied on a 1999 balance sheet that she claims she printed from our last marital home in Orlando, Florida. But oddly, she claims she printed it from QuickBooks at that house, but it was after I moved to South Carolina. So I'm a little confused about those balance sheets. They were unsigned and they were prepared by her, and she submitted them at trial. But they were over 20 years old.
All right, sir, you have used your initial allotment of time. We'll hear from Ms. Morgan, and then you'll have your 5 minutes for rebuttal. Ms. Morgan?
Yes, Your Honor. This is Cindy Morgan from the White County Bar. This was a divorce. It was a lengthy divorce that we had volumes and volumes of discovery involved in it. And then we come to trial and we still don't have a key element of this case, which is documents that would document where approximately, I think the numbers was right at $4 million that he had at the time of separation that was evidenced by the balance sheets that were entered into evidence. He claims that he had such losses such as the Enron stock, which was about $400,000. He had some other losses that he claims were due to the market turn down and the sale of the condos in his homes and things like that. But when it gets to the nitty gritty and what we did, we showed that at the time that he sold these assets, those losses had already been incurred. He owed nothing at the time of each one of these sales of these assets. We documented over $2 million worth of sales of assets during that time period, shortly after their original divorce was filed in Florida. It was dismissed. After that, it seems to me that there was a dissipation of funds. The missing documents was all the records that had to do with where these funds were deposited. Approximately $2 million was deposited, where those funds went. In the record, Mr. Julian states that he has these on QuickBooks, that he didn't think that that's what we were asking for. He didn't bring them before the court. He says all that's documented. But that was the day of court after lengthy discovery, trying to get to the heart of this. Where did this money go? Where did $4 million go? And then we look at it and we're going back and forth. He's got detailed records with regard to purchases of cars, where he paid insurance over these same time periods, but no records as to where this money went. And Your Honor, of course, we argued that there was more than just the $400,000, that he didn't account for a large portion. If we take off what he claimed as loss is $400,000 on the Enron stocks, it still doesn't account for $3.6 million. And there's simply nothing in the records that would suggest that he had these losses during this time period. Additionally, as to the...
You didn't raise that as an issue on appeal, though, did you? That
We did.
I'm sorry?
We did.
That the trial court did not award you sufficient assets?
Yes, Your Honor. Our argument one is whether the trial court erred and determined that Duane Julian's net worth was $400,000 so as to provide a division pursuant to the prenuptial of $200,000. And in that argument, we argued that it should have actually been more.
Okay.
And as to the investment in the trading account, we provide proof that Mr. Julian actually claimed all the income on his taxes, on his separate taxes from that trading account. He claims it was his father's money, but he claimed the actual, he offset it against his losses that he had incurred before, but he included that income on his taxes during the year that $400,000 was invested. He cashed out about $500,000 out of that account and then transferred those funds to his father. Every time there's any asset throughout this marriage, through the divorce proceedings, when he received any monies, he would transfer them to his family, claiming he owed them those monies. If it be the Volkswagen settlement, he bought a new Volkswagen when they did the settlement because of the EPA regulations. They sent him the money. He immediately transferred that money to his brother, claiming that he owed his brother that money. He even had he had a document signed saying that he had loaned him this money during the proceedings of this divorce. The other thing that we pointed out to the court was during this time period that he's claiming poverty, that he is out of assets, he has no monies, he's paying $2,500 to $3,000 a month each month on credit card accounts. And simply, if you have no money, you have no job, you have no assets, you don't do that type of activity. In addition to the issues with regard to the funds and what he did with the funds.
Let me ask you about the evidence for just a moment. Did you have an expert examine this and try to trace the funds, or was this just the testimony of the parties, basically?
It was just the testimony of the parties. We couldn't get enough records from that missing time period in order to get an accountant to look over to see where the monies went. We were basically from 1999 to about, I think, the 2010, there was just missing records where all these funds were transferred. By the time that we started with records, there were no assets in those records that we received. And that's what we were trying to get. And again, Mr. Julian testified that he had QuickBook records on his computer at home, but we just didn't ask the right questions. But he certainly did not bring those before the court. And I think that the court looked over all the claims of Mr. Julian and stated, even if you accept the losses that you say that you've had, there's still about $400,000 unaccounted for. We, of course, state that we believe there's a lot more than $400,000 unaccounted for, but the court certainly looked at the pros and cons, what he said that he lost based upon what we said that he had, and still found that there was assets to be had. Mr. Julian didn't bring up the issue of the alimony, but I'd like to argue the issue of the alimony. I think the court went through all the steps to determine alimony, but the first thing was whether or not you get past that prenuptial agreement that says that there would be no alimony awarded. Mr. Julian comes in here and says, I'm a public ward now. I draw food stamps. Well, Your Honors, simply making yourself a public ward, not working, not doing anything to support yourself and saying, I'm going to sit home and you pay me alimony is not enough to get past that clause in a prenuptial. You cannot make yourself a pauper, make yourself a public ward, and then claim that we should set aside a provision in alimony. He has the ability to work. He had a car salesman's license. He obviously had great business aptitude. He had a business that earned him assets in over $4 million. And there's simply no reason for alimony to be awarded in this case. We would ask and believe that it's supported by the evidence that she received her $500,000 under the prenuptial. I think there's that much money missing in this accounting of the assets. And we would state that there's no reason that alimony should be awarded. And we've also asked for attorney's fees in this matter to be awarded as a frivolous appeal in this matter.
Is that the basis that you're requesting the attorney's fees as a frivolous appeal?
Yes, Your Honor.
Okay. Anything further, ma'am?
No, Your Honor.
Okay. All right, Mr. Julian, you have your rebuttal time. We'd be pleased to hear from you.
Several items. Ms. Morgan just told you that she never had an accountant, but that's not what she told the trial court judge on June 1st. She told the trial court judge to get an extension for 3 months on the trial, that she'd sent all the final bank statements and tax returns to the accountant in Florida. And the trial court judge asked her, when would he be finished? And when was she sent those records? She said 2 to 3 weeks ago, and she'd be finished in 2 or 3 weeks. The trial court judge found there was no outstanding discovery on my part remaining, but it did order her to do further discovery, including an affidavit that she'd supplied all her own. Ms. Morgan also states in her opposing brief that I had $4.9 million in 1999, and that it's uncontroverted. But it's contradicted by her own client at trial when she testified it was only 3.6 million. So Ms. Morgan's opposing brief has a $1.3 million discrepancy in it that more than accounts for the 1 million she claims it's missing now, much less the trial court found the 400,000 that I believe was plucked from thin air. Also, this allegation that I was spending thousands of dollars per month while claiming to be a public charge is not true. She has her time periods wrong. I did spend $2,000 to $3,000 a month on credit cards before my financial condition deteriorated much worse. But much of that was the result of making charges on my credit card for my father's business, because I took it over from a man that was defrauding him using credit cards. So much of this I put on my own credit cards, and the company reimbursed me. She then claimed I was funneling money through my father's checking account and business account, and the court ordered me to provide all my father's accounts because I was a signer on that. I provided all those accounts. The judge had a status hearing on that matter, went through all the records. There was no evidence of me funneling any money through my father's account. Found that I did comply with discovery, and then set the matter for trial. Again, he clearly ordered her to file a list of outstanding discovery 8 months before the trial, and she didn't file any. That should dispose of her discovery demands, and that even came 3 months later. So I don't think she should be heard to argue about discovery when she had all these years to get it, and made representations to the court that she sent the quote final records to the accountant in Florida, who was going through all the bank statements and tax returns to compare them. We never heard again from this so-called accountant. He never appeared at trial. We never had any statements from him whatsoever. So I think that should be dismissed as not credible, her not having an accountant and all that. As far as not working, I'm taking care of my father. He'll soon be 98 years old. He's suffering from advanced Parkinson's. I think I have an obligation to try to take care of him. They say it is by my choice, which it is. It's what I promised my mother I would do. I don't regret it. He needs my help. And at some point later, I hope that maybe I'll be in a position where I can work. But right now, I don't have a house. I don't have income. I don't have a car. I'm not in a position to really work. And if I did, I'd leave my father without someone to help take care of him, and would likely not make enough money to even afford my own house or car anyways. So it's not that I'm not willing to trade work. I'd trade any job if it did restore my father's health. So there's a lot of discrepancies here in what she's telling you, particularly the $1.3 million that she makes a mistake in her brief that she says is not contradicted, when in fact, Mrs. Julian contradicts it. And I don't think my brief is frivolous whatsoever. I brought it in good faith, and I supported it with the record evidence and the transcripts.
Are you investing funds for other parties now, Mr. Julian?
I'm sorry, I couldn't hear you, Judge.
Are you investing funds for other parties currently?
No, I stopped doing that when, at the end of the TD Ameritrade promotion on April 2015. It was a one-year promotion, so we reactivated the account in 2014 April. It ended in April 2015.
Okay, all right.
All right, counsel and Mr. Julian, we appreciate your argument. We will review the record, prepare an opinion, try to get it to you as quickly as possible. We again appreciate your participation in this video oral argument. It's still new to us and we're still getting the kinks worked out, but we appreciate it. And thank you very much, Ms. Tivner. You may conclude this case.
This honorable court is now in recess until 10 a.m.
Thank you.